Tonight, we begin with a development that immigration attorneys, policy experts, and couples across America had feared, anticipated, and prepared for. A shift that unfolded not over years, but in weeks. Weeks that have transformed how marriage green cards are processed. Weeks that have left thousands of couples scrambling for answers. Weeks that have rewritten the rules that spouses thought they understood. What the Trump administration did recently crossed a line that immigration advocates had hoped would hold. And when that line broke, families did not hesitate. They responded with urgency, determination, and a desperate need for clarity. Because when it comes to marriage green cards under this administration, what you don't know can separate you from your spouse indefinitely. For months now, there had been signals, not official announcements, not formal policy memos, just signals, that the administration was preparing something unprecedented. The Trump administration has been aggressive on immigration, yes, but they have been strategic in their aggression. Their moves have followed a certain logic, a pattern, almost a predictability. But what set off alarm bells in immigration law offices across America this month was that the pattern went silent. Attorneys who monitor USCIS operations know the indicators: the sudden policy guidance updates, the increased request for evidence notices, the unexplained interview reschedules, the sudden shift in approval rates. All of that went quiet. And whenever USCIS goes quiet, it means something is about to get loud. The marriage-based green card process, once considered one of the more straightforward paths to permanent residency, has become a minefield of new requirements, heightened scrutiny, and unpredictable outcomes. Spouses who thought they had done everything right are now discovering that the rules have fundamentally changed. Early this year, immigration policy analysts detected what they described as systematic procedural overhauls, including enforcement priorities that had not been implemented in over 2 decades. These are the kinds of changes that USCIS only deploys when they are signaling something very specific. Fraud prevention is the primary focus, extended vetting as standard procedure, or complete restructuring of approval criteria. Immigration attorneys didn't know which category this fell into, or whether it fell into all three at once. But what they did know was that the administration was changing its posture on marriage green cards. And when any administration shifts posture without explanation, even by small measures, every couple with a pending application pays attention. The I-130 petition for alien relatives and the I-485 adjustment of status application, the 2 primary forms for marriage green cards, are now being scrutinized like never before. Cases that would have been approved in 90 days are now taking 18 months or longer, and the reasons for denial have expanded dramatically. The advisory issued by immigration law associations tonight was not normal. It was not routine. It was not symbolic. It was urgent. Attorney after conference call described the administration's moves as unprecedented in scope, deliberately opaque, and perhaps most importantly, retroactively applicable to pending cases. But confusion only works if couples remain uninformed. Informed spouses are not remaining passive. In fact, their response today was among the most organized we've seen in immigration advocacy. Here's what we know. Within weeks of the new guidelines taking effect, immigration attorneys filed thousands of inquiries. These weren't the standard case status checks. These were formal complaints and congressional inquiries, tools that attorneys only deploy when they are preparing to challenge systemic problems. Couples are now gathering documentation they never thought they'd need. They're preparing for interviews that probe deeper than ever before, and they're learning that the marriage green card process they researched 6 months ago no longer exists. Tonight, immigration policy experts confirm that USCIS has launched enhanced vetting protocols on marriage-based applications, including cases that had recently been approved conditionally for what analysts believe was preliminary clearance only. The administration acted before couples could anticipate the changes. They hit the interview process, they hit the documentation requirements, they hit the timeline expectations that were already causing family separations. In other words, the administration targeted every stage of the marriage green card journey, the predictability that would have made planning possible. This is what made the legal community's warning so urgent. The administration's approach wasn't just symbolic, it was actionable. It represented the kind of change that could deny legitimate couples if left unchallenged. And immigration advocates, understanding that fully, responded with force. Not recklessly, not impulsively, but strategically. They didn't file frivolous lawsuits. They didn't spread panic without solutions. They hit the policy weaknesses with legal challenges. They hit the information gaps with comprehensive guides for affected couples. Here are the essential changes every spouse must understand. Change 1. Extended processing times. What once took 6 to 12 months now regularly exceeds 24 months. Couples must plan for extended periods of uncertainty. Change 2. Intensified fraud scrutiny. Every application is now treated as potentially fraudulent until proven otherwise. The burden of proof has shifted dramatically. Change 3. Expanded document requirements. Joint bank statements and lease agreements are no longer sufficient. Couples need years of evidence demonstrating a genuine relationship. Change 4. Aggressive interview tactics. Separate interviews with detailed questioning about daily routines, relationship history, and even bedroom arrangements are now standard. Change 5. Public charge considerations. Financial requirements have become more stringent, with income thresholds and sponsorship obligations receiving heightened attention. And here's where the story becomes even more concerning. Policy analysts now believe that the administration's latest moves were designed to test the resilience of marriage-based immigration after years of perceived leniency. The administration wanted to see whether couples would abandon applications under pressure. But instead, the opposite happened. Couples didn't give up. They organized with determination that was so unified, so persistent, that even policymakers noticed. You don't get the administration's attention easily, but today, affected families did. Immigration attorneys speaking with media under anonymity described the policy shift as deterrence by exhaustion, a way to reduce approvals without officially changing eligibility criteria. But couples proved today that they remain both committed and informed. Their documentation was not only thorough, it was organized so precisely that denial rates for well-prepared applications remained low. That preparation matters because it shows couples are adapting. It shows that spouses are not passive victims. They are active participants in protecting their families. The couples who succeed under these new conditions share common traits. They start gathering evidence from day one of their relationship. They maintain meticulous financial records. They document their life together comprehensively. And they seek legal counsel before problems arise. As reports continued coming in throughout the week, we learned more about the scale of the administration's approach. USCIS field offices carried out policy standardization, forcing regional variations to disappear. Immigration enforcement targeted cases that had been pending in the last 2 years. Background check agencies operating nationwide reportedly expanded databases used by USCIS to verify relationship authenticity. This wasn't just policy adjustment. This wasn't just procedural refinement. This was systematic transformation. This was operational overhaul. An operational overhaul is the one thing that previous administrations had avoided since comprehensive immigration reform failed. For every accommodation couples had relied upon, the administration has countered with something that complicates their path forward. The numbers tell the story. Requests for evidence notices have increased by over 40%. Interview wait times have doubled in major metropolitan areas. Denial rates for cases lacking extensive documentation have tripled. And the conditional green card removal process, the 2-year review for recently married couples, has become its own obstacle course. Remember, many couples thought marriage to a citizen meant automatic approval. They thought love would be enough evidence. They thought the process would be straightforward and predictable. But tonight, the exact opposite is happening. Documentation requirements exceed anything in recent memory. Interviews probe deeper than couples ever anticipated, and approval is never guaranteed, regardless of how genuine the marriage. This represents a fundamental shift in how marriage green cards are processed. Previous administrations operated on a presumption that most marriages were legitimate. This administration operates on a presumption that every marriage must prove its legitimacy. That philosophical difference affects every single application. What makes this moment so critical and so unpredictable is that the administration's latest moves happened at a time when immigration policy is under intense political pressure. Conservative advocates want reduced legal immigration. Business groups want streamlined processes. Family advocates want humanitarian considerations. Legal scholars want constitutional compliance. The administration is balancing these demands while pursuing campaign promises on immigration enforcement. And when leaders in that position make sudden moves, they're not doing it from a single motivation. They're doing it from multiple pressures. They're doing it from political calculation. For couples, this means policies can shift without warning. What's acceptable documentation today might be insufficient tomorrow. What's a standard timeline now might extend indefinitely next month. The uncertainty itself becomes a burden that couples must carry throughout their application process. USCIS's official guidance, now distributed through updated policy manuals, was designed to signal that the agency is not willing to allow perceived immigration fraud. Officials said plainly that previous approval patterns were inconsistent with current enforcement priorities. That is bureaucratic language for, we're changing everything, and past precedent no longer applies. You don't usually hear that tone from USCIS unless something serious is at stake. The message to couples is clear. Assume nothing based on what friends experienced. Assume nothing based on what you read online from previous years. Assume only that your case will be scrutinized more thoroughly than you expected, and prepare accordingly. Meanwhile, immigration advocacy leaders addressed affected families in a direct, sobering message tonight. They said, "The rules have changed, and pretending otherwise helps no one." They said, "Preparation is no longer optional, it's essential for survival." And they said, "Couples who treat this process casually will face consequences. Couples who prepare will avoid." These are not rhetorical flourishes. These are statements from organizations that understand just how high the stakes have become. The difference between approval and denial often comes down to preparation. The difference between family unity and separation often comes down to documentation. And the difference between a smooth process and years of uncertainty often comes down to legal guidance. Here's what makes the situation even more concerning. The administration's latest moves weren't isolated to marriage green cards. Along with marriage-based application changes, travel restrictions also affected spouses with pending applications. Work authorization processing also experienced delays. Removal proceedings increased for cases with any irregularities targeting vulnerable applicants. All of this happened within the same policy cycle. When an administration moves multiple pieces at once, it means something larger is underway. The comprehensive approach suggests a fundamental reimagining of family-based immigration. Couples cannot view their marriage green card application in isolation. They must understand it as part of a broader enforcement environment that affects every aspect of their immigration journey. Immigration analysts are now considering several possibilities. One is that the administration is preparing permanent regulatory changes to marriage-based immigration. Another is that the administration is attempting to reduce approval rates through procedural obstacles. A third possibility, the one worrying advocates the most, is that the administration is attempting to fundamentally transform who qualifies for marriage green cards. But today, prepared couples took that uncertainty off the table. They didn't submit incomplete applications hoping for the best. They didn't skip legal consultation to save money. They didn't assume their relationship would speak for itself. They prepared comprehensive evidence packages that left no question unanswered. And those couples are still getting approved. The path is harder, but it remains open for those who take it seriously. What we're watching now is a test of commitment. The administration wants to see how many couples will abandon applications. Couples want to show that legitimate marriages will persist through any obstacle. Immigration attorneys want to prevent unjust denials, and families want to prevent permanent separation. The test is not whether you love your spouse. The test is whether you can prove it to a skeptical government. And that test requires preparation most couples never anticipated. Tonight, we've heard from immigration attorneys who are now monitoring case outcomes daily. They say approval rates remain strong for comprehensively documented cases. They say denial rates have increased primarily for underprepared applications. And they say the administration's decision to heighten scrutiny is likely part of a broader deterrent strategy intended to reduce application volume. But couples are not being deterred. In fact, couples are becoming more determined. Their response today, organized, documented, and legally supported, sent a message to the administration that legitimate marriages will fight for recognition. And it sent a message to other couples that success remains possible with proper preparation. As the months go on, we expect more details to emerge about what exactly the administration hoped to achieve. But what we do know is that legal preparation is timely. It prevents unnecessary denials, it shortens processing delays, and it protects families from separation. What happens next will depend on what couples do in the next few months. If they prepare thoroughly, this moment will be remembered as a challenge they overcame. If they neglect preparation, the consequences have already been demonstrated through increased denials. Advocates have shown they are ready to support couples. They have shown they are ready to respond. And tonight, for the first time in years, the marriage green card process appears to be in flux. USCIS policy offices are quiet, too quiet. And when the administration is quiet, it means they are planning. It means they are choosing their next changes carefully. Because tonight, couples learned something they must remember. Love is not enough documentation. Hope is not a strategy. And preparation is the only protection. This story is far from over. But tonight, one thing is clear. Couples who prepare will succeed. Couples who ignore these changes will suffer consequences. And the marriage green card process will never return to what it was. And we will be here, watching every detail as the next phase unfolds. Stay informed, stay prepared, and never assume the rules from yesterday apply today.